Start. Counsel for the appellant pressed hard upon us that the defense evidence establishes the alibi of the appellant. We think not. The evidence led by the appellant to show that at the relevant time he was on duty at his usual place of work at Naini has a certain amount of plausibility, but that is about all. The High Court and the Sessions Court have pointed out many a reason why that evidence cannot be accepted, and the Indian telephone industries made a brave bid to save his life by giving evidence suggesting that he was at his desk at or about the time when the murder took place, and further that he was arrested from within the factory. We do not want to attribute motives to them merely because they were examined by the defense. Defense witnesses are entitled to equal treatment with those of the prosecution, and courts ought to overcome their traditional instinctive disbelief and defense witnesses. Quite often they tell lies, but so do the prosecution witnesses. Granting the DW 1 to 5 are right, their evidence, particularly in the light of the evidence of the two court witnesses, is insufficient to prove that the appellant could not have been present near the Hathi Park at about 9 a.m. when the murder of Pappu was committed. The plea of alibi postulates the physical impossibility of the presence of the accused at the scene of offense by reason of his presence at another place. The plea can therefore succeed only if it is shown that the accused was so far away at the relevant time that he could not be present at the place where the crime was committed. The evidence of the defense witnesses, accepting it at its face value, is consistent with the appellant's presence at the Nani factory at 8:30 a.m. and at the scene of offense at 9 a.m. So short is the distance between the 2 points. The workers punch their cards when they enter the factory, but when they leave the factory, they do not have to punch the time of their exit. The appellant, in all probability, went to the factory at the appointed hour, left it immediately, and went in search of his prey. He knew when precisely Pappu would return after dropping Ranjana at the school. The appellant appears to have attempted to go back to his work, but that involved the risk of the time of his re-entry being punched again. That is how he was arrested at about 2:30 p.m. while he was near the pawn shop in front of the factory. There is no truth in the claim that he was arrested from inside the factory. In the case of Vinay Kumar Singh vs. State of Bihar 1997, 1 SCC 283, the Honorable Apex Court in paragraph numbers 22 and 23 has observed as under. We must bear in mind that alibi, not in exception, special or general, envisaged in the Indian Penal Code or any other law. It is only a rule of evidence recognized in Section 11 of the Evidence Act that facts which are inconsistent with the fact in issue are relevant. Illustration given under the provision is worth reproducing in this context. The question is whether a committed a crime at calculated on a certain date. The fact that on the date A was at Lahore is relevant. The Latin word alibi means elsewhere, and that word is used for convenience when an accused takes recourse to a defense line that when the occurrence took place he was so far away from the place of occurrence that it is extremely improbable that he would have participated in the crime. It is basic law that in a criminal case in which the accused is alleged to have inflicted physical injury to another person, the burden is on the prosecution to prove that the accused was present at the scene and has participated in the crime. The burden would not be lessened by the mere fact that the accused has adopted the defense of alibi. The plea of the accused in such cases need be considered only when the burden has been discharged by the prosecution satisfactorily. But once the prosecution succeeds in discharging the burden, it is incumbent on the accused who adopts the plea of alibi to prove it with absolutely certain, so as to exclude the possibility of his presence at the place of occurrence. When the presence of the accused at the scene of occurrence has been established satisfactorily by the prosecution, though reliable evidence, normally the court would be slow to believe any counter evidence to the effect that he was elsewhere when the occurrence happened. But if the evidence adduced by the accused is of such a quality and of such a standard that the court may entertain some reasonable doubt regarding his presence at the scene when the occurrence took place, the accused would no doubt be entitled to the benefit that reasonable doubt. For that purpose, it would be a sound proposition to be laid down that in such circumstances the burden on the accused is rather heavy. It follows, therefore, that strict proof is required for establishing the plea of